Donald Trump's comments on birthright citizenship have stirred up some controversy this past week. And with me now is constitutional law attorney who served in the Reagan and Bush senior administrations, David Rifkin. All right, good evening, David. So has the Supreme Court ruled that children of illegals are American citizens?
They have, Judge. The earliest case to hold that is a late 19th century case, United States versus Wong Kim An, where there was a question whether or not a child born in San Francisco to a Chinese parents who were not here on official duty could come back into the United States. He was not allowed to come back initially because of so-called Chinese exclusion acts, and the Supreme Court clearly held that. Supreme Court reiterated that position in a much more recent case called
But let me, hold on. I want to talk to you about Wong Kim. Wong Kim's parents were not illegals. They, in fact, were permanent. They had permanent domicile in the United States, so they were here legally. The question I asked you is whether the United States Supreme Court has ever ruled that children of illegals are American citizens. Wong Kim does not stand for that.
There's no case that considered this very question, but let me explain why it's irrelevant. The Supreme Court has ruled.
Let's take a look at the 14th Amendment, just because we don't have a lot of time. The 14th Amendment says that all persons born here are naturalized in the United States and subject to the jurisdiction or citizens of the United States. Now, what does subject to the jurisdiction mean?
This means an individual who is subject to the authority of the United States government, the force of United States laws. And, Your Honor, this very question was considered by the Supreme Court in several questions. This question was also considered during the legislative history leading to ratification, enactment, and ratification of this amendment. But what it means basically is everybody except for foreign diplomats, foreign soldiers, and perhaps Indians on tribal land.
Okay.
So
now, yes, go ahead.
That's what it means. Your status as lawful or unlawful immigrant is irrelevant. It's the fact that you're subject to the laws of the United States.
All right. Section 5 of Amendment 14 says that Congress shall have the power to enforce by appropriate legislation the provisions of this article. Now, in 1923, Congress reversed and granted citizenship to all Native Americans. Now, that was contrary to the 14th Amendment. So that tells me that Congress can go against specifically what's written in the 14th Amendment, since they have the jurisdiction over that amendment. What does it tell you?
With respect, it's not true. First of all, the language you are talking about enables Congress to do nothing more than enact legislation that carries into force the language of a 14th Amendment. Number one, as to the Indian tribes,
that's not correct. That's not correct.
Congress
it specifically says that it gives them the power to enforce by appropriate legislation the provisions of this article, and yet the 14th Amendment was changed by Congress in 1923 when they granted citizenship.
It was not. It was not.
Really?
Let me explain very briefly. The reason originally the Indian tribes were not viewed in this light is because they were very much autonomous. By the early 20th century, there had been so much legislation that impacted, if you will, diminished their sovereignty, that they were subject to the jurisdiction of the United States.
David, thank you so much.
Change.
I'm sorry we don't have a lot of time. We're going to be right back with your reaction to my Trump interview. Stay with us.